go and see the chat. Okay, hang on. Hi, everybody. Oh, what a day. I've been out for hours. If you are a member or a Patreon, you could have been in our Zoom with us. We went on a lot of field trips today. I took you all the way out to Wilkes-Barre, Pennsylvania. I took you to a warehouse for estate sale stuff, and then we went to a gorgeous, gorgeous, gorgeous store that has all vintage antique stuff. After that, we had to go to the Dollar Tree. We went to, where'd we go after that? Where'd we go after that? Oh, we went to Moosac Mountain, Pennsylvania. Then went, grabbed something to eat real quick. Went into Walmart. Went into Home Goods. Well, switched the order. And then drove home, and I got here probably not too long ago. So yeah, we've been out. What time is it now? 1:45. Probably close to 12 hours. And Nicole was also. Were you also out? You were also out, and I think Chris Ree went out somewhere, and somebody else took us somewhere. Tammy took us somewhere, I believe, and Kevin. No, he didn't take us anywhere. Sharon, yeah, we had a good time. So yeah, become a member, become a Patreon, and you can be on trips like that. So we were on a road trip all day. Anyway, I mean, everybody else was there, and we had a lot of other people there, Lark and Deborah, Vancouverden, and Earthbound Spirit, and other people jumped in and out all day. I don't even know how many people were in and out because I was walking around showing stuff and not really able to concentrate on too much stuff, but we had more people than that too in there. But it was fun. Oh, there's Whisper to Me. Whisper to Me. Where have you been? We've been waiting for you. Hope you're okay. And let's see. Hi, Liza Ward. Let me see. I was just trying to make sure I have all my bracelets on. Oh my gosh, what a crazy time. You're doing crossword puzzles. Hi, K-Love. How are you? But why wasn't I let into the Zoom? Who didn't let you into the Zoom? What are you talking about? When? When? I wasn't even a co-host. I have no idea, Ceci, when. You're good? That's good. So, yeah, we had that, and we've got a lot of special stuff, and we're going to have a special sale tomorrow. I've got a lot of special stuff, and I think Chris Ree has a lot of special stuff, and yeah, so we're gonna have a sale tomorrow, and it'll depending. Okay, if it Jimmy, you know what the weather's gonna be like tomorrow?
I'll tell you 1 second.
If it's gonna be horrible weather, I'll start the sale early. If it's not gonna be horrible weather, then I want to ride my bike and stuff. Especially, I mean, I did a lot of walking today, but
I think tomorrow morning is, man, I'll let you know.
Oh, about an hour ago, Sassy? I was home by then.
It's going to be raining.
It's going to be raining? Oh, good. Okay. If it's raining and it's raining bad and I'm not able to go outside, hi, Rosalita, we'll start the sale earlier. Maybe start it in the afternoon and let it go.
But it might stop by the afternoon.
All right. Well, it's going to depend on the weather. It's going to depend on the weather. But I didn't hear anything. An hour ago, I would have been either in the car and on my way home, and I didn't hear any bells. So I'm not sure. Gail said she didn't hear the doorbell either. And an hour ago, I would have been in the car or just gotten home and there were no bells. But see, I think there's something glitching because Nicole said that happened to her. When was it? Last week, and there was no doorbell and nobody saw her anywhere in the waiting room. So I don't know, but I didn't hear a doorbell. Definitely would have let you in. Didn't hear that. But you would have already missed the whole trip by then because you would have just caught me coming home. So you had to log on earlier. We were out from, I don't know, like early afternoon right through, I think I left there around 11:30. Already happened to me a couple of times. I kept calling in. Yeah. Happens sometimes, Norbert. Oh. Hey, Deborah Kent. Hi. Oh my gosh, good to see you. How's everything going? Good. Happened to you too, Liza? Yeah, something's buggy. I think it happened to me once as well. I was like, why isn't it really me? I had to run around the kitchen, let myself in. When I was in the massage chair. Okay.
They do it to me. She does it to me all the time.
Yeah. Hi, Heart Made Wise. It happened to me too. I had to keep coming in and out and out. Yes, somebody did mention that. Who the heck was that? Sharon said she had to come in and out a bunch of times before she got in or something. Somebody mentioned it recently too. So it might be, I don't know if it's getting close to the time that the Zoom is expiring, because when did we start this Zoom? Kevin usually keeps track of it. But when did we start it? Probably getting ready to expire. You'd have to leave and try again a couple of times too. Yeah. Okay. So everybody learned a lesson. If you don't just stay there and wait, try to come back in and out again, in and out again, in and out again. 246. Okay. So this Zoom is probably gonna collapse during this live, right? Hi, Daniel. All right. So yesterday we were talking a lot about Adnan Syed and his conviction. Hey, Leah Jane. How are you? Haven't seen you in a long time. I hope you're okay. So everybody was talking about the case that was here and a little bit shocked that it was overturned so quickly. But I have to tell you, when I listened to the Serial podcast, I had never listened. I don't think I ever read those interviews with Jay Wilds, and it was just absolutely wild. So I want to do a little more digging into that tonight and do some, like, a true crime deep dive into that part of it, because when I was listening to that guy, I'm like, this stuff doesn't sound good. So in that respect, I'm more leaning that Adnan didn't do this. The way I hear about him talk about the resentment, I also want to go on because they did say that one of the suspects is in jail now, prison. So is that Jay? So I want to figure that out there and see what's going on. So let's check that out and see what's up with that. And can you do me a favor, Jimmy?
What?
Could you put this on the charger? I'm sure this probably needs to be charged really badly. Thank you.
You're welcome.
Okay. It was probably my fault. You were sleeping. Oh. Okay. Narcoleptics. But I don't think so, because I think if it was an hour ago, I would have been in earshot and I didn't hear it. And people have been saying it's been glitching. So let's see if we're Jay Wild. Where is Jay Wild now? Okay. So let's here's something new. Okay, it said Heyman Lee's family would have okayed Adnan's release if new evidence was solid, they said. The family of Heyman Lee, who was allegedly killed at the hands of Adnan Syed, would have been all good with his release, but they say they haven't seen any solid evidence pointing on anyone else, at least not yet. Attorney Steve Kelly, who's repping the Lee family, told TMZ that Heyman's brood simply doesn't think that prosecutors submitted to cut Adnan loose. Doesn't think what prosecutors submitted to cut Adnan loose was convincing, adding, they don't consider it real evidence that actually points to another killer or killers. The attorney says the Lee family was told for 20 years by the Baltimore State's Attorney's Office that Adnan was their man, responsible for Heyman's death, something a jury at the time agreed with when they convicted him of murder and sentenced him to life in prison. Now we're told they feel the rug has been pulled out from under them. Kelly tells people that the Lee family would have absolutely consented to springing Adnan out of prison if they actually bought the arguments that prosecutors made in their recent court motions. Let's see. Prosecutors pointed to notes and or letters from at least one potential suspect who was apparently known to cops from the jump and who apparently wrote they wanted to make Heyman Lee disappear and kill her. The problem, according to prosecutors, is the notes were not handed over to Adnan Syed's defense team during the trial, which is a big no-no because any evidence that potentially exonerates Adnan Syed should have been handed over. Not just that, but prosecutors are also saying a key witness, Jay Wilds, gave inconsistent accounts to police, which he did. Apparently, much of the stuff wasn't disclosed to Adnan's team, and prosecutors are saying it all warranted throwing out the conviction. As we reported, a judge agreed Monday, and Adnan be cut loose, although he'll remain on house arrest for 30 days while prosecutors decide whether to retry him. While some say this is significant evidence and more than enough to raise reasonable doubt, the Lee family believes there's not enough to persuade them that Adnan should go free. Tackle on the claim that they were blindsided by the state attorney's office, which head honcho Marilyn Mosby has since denied. Okay, so we have that first. Okay, now let's see. All right, hang on a minute. Let me see something here. Okay, so the claim that one of the suspects has assaults against women in their history matches up to Jay. It's also been stated that Jay has a relative with property near where Hayes' car was another detail given on the suspect. I believe that Jay could be one of the suspects that's being looked into again at this point. By new suspect, that's referring to the two suspects that are being looked into again from the original investigation. Let's see what this is. Here's a plea agreement. Here's Jay's plea agreement. Let me get this up. Okay. So this was the plea agreement. Up, get over there. Get over there. State of Maryland versus Jay Wilds. This agreement contains the terms and conditions that have been reached between the Office of the State Attorney for Baltimore City, referred to in this agreement as this state, and the defendant in the above captioned case, referred to in this agreement as the defendant. The terms of this agreement are as follows. The defendant agrees to cooperate with the state on the following terms and conditions. The defendant represents that he or she has fully and truthfully responded to all questions put to the defendant by law enforcement authorities during all prior interviews. If at any point it becomes evident that the defendant has not been truthful concerning his involvement in this incident, the state is immediately released from any obligation under this agreement. The agreement becomes null and void, and the state is free to bring any charge against the defendant supported by the evidence. The defendant shall continue to cooperate fully with the state by providing full, complete, and candid information concerning the murder of Hae-Min Lee, of which the defendant has knowledge. The defendant shall cooperate completely with the state, including any other law enforcement authorities designated by the state, including federal authorities, in any matter as to which defendant's cooperation may be relevant. Defendant shall comply with any and all reasonable instructions from such authorities with respect to the specific assistance that the defendant shall provide. C. The defendant shall testify fully and truthfully before a state or federal grand jury and at all trials or other proceedings in which the defendant's testimony may be relevant. D. The defendant agrees to make himself available as needed for any court hearings and trials where his testimony is needed. He shall be responsible for seeing the state has the means to contact him. Further, the state will request a warrant for the defendant's arrest if he is in violation of this paragraph. The defendant will tender a guilty plea to one count of accessory after the fact to the murder of Hae-Min Lee, and the defendant expresses that the defendant fully understands the maximum penalties and fines for each and every charge as stated. In consideration for the complete fulfillment by the defendant of each and every term and condition of this agreement, the state agrees to do the following. At the time the defendant executes this agreement and tenders a guilty plea, as stated above, the state will recommend to the court the disposition be set at a future date, specifically at a date after all trials where defendant's testimony will be needed. When the defendant appears before the court for sentencing for the offenses to which the defendant has pled guilty, the state will bring to the court's attention and the court will consider the nature and extent of the defendant's cooperation, all other relevant information regarding the defendant's background, character, and conduct, including the conduct that is subject of the various counts of the above captioned indictments. Any failure by the defendant to fulfill any or all of defendant's obligations pursuant to this agreement, at defendant's sentencing, the state will make a recommendation regarding the sentence defendant shall receive based upon the extent of defendant's cooperation pursuant to this agreement. If the defendant completes all of these terms and conditions stated in this agreement to the satisfaction of the state will recommend a sentence as follows: 5 years to the Department of Corrections with all but 2 years suspended, with 3 years supervised probation. Said recommendation to serve as a cap. If the defendant fails to complete each and every obligation under this agreement, the state will recommend a sentence as follows: 5 years to the Department of Corrections. Whether or not the defendant has completely fulfilled all of the obligations stated in this agreement shall be determined by the court at the time of the defendant's sentencing. Nothing in this agreement shall be construed to protect the defendant from prosecution for perjury, false statement, obstruction of justice, or any other crime. This agreement does not protect the defendant in any way from any prosecution for offenses which occur after the execution of this agreement or for any crimes that may have occurred prior to this agreement and are not part of this agreement as enumerated above. If the defendant compromises these investigations intentionally or through gross negligence, if the defendant is not completely candid and truthful in the performance of this agreement, if the defendant flees, attempts to flee, or fails to appear for defendant's sentencing, The state and the court will be completely released from any obligations under this agreement, and the state may recommend and the court may impose the maximum penalties for each and every offense to which this defendant has tendered a guilty plea pursuant to this agreement. This includes the state's invocation of the minimum mandatory years. The defendant shall not be permitted to withdraw a guilty plea tendered pursuant to this agreement under any circumstances. The defendant understands that this agreement is as it appears and that it is very harsh agreement. The state makes no representation that this agreement will be easy for the defendant to complete. The defendant agrees not to ever disclose the terms of this agreement or the existence of this agreement to anyone except the defendant's attorney if the defendant has acquired legal counsel. In addition, the defendant agrees not to disclose the names or any other identity of any law enforcement authorities who are a party to or otherwise involved in the performance of this agreement. The state reserves the right to require the defendant to perform specific acts in regard to the investigation and targeting the defendant to sign an addendum to this agreement, targeting or specific individuals or organizations. The state may require the defendant to sign an addendum to this agreement that identifies those specific acts. There are no other agreements, promises, or understandings between the defendant and the state. This agreement can only be amended in writing, signed by all parties. The defendant expressly waives any right to preliminary hearing or indictment by a grand jury. And so that was signed there. And let's see, this next one is the motion to vacate the conviction. So in here, okay, after a nearly year-long investigation by the state and defense, who is represented by Erica J. Suter of the Office of the Public Defender and the University of Baltimore's Innocence Project, the parties have uncovered Brady violations and new information, all concerning the possible involvement of two alternate suspects. Additionally, the parties have identified significant reliability issues regarding the most critical pieces of evidence at trial. Investigative efforts are ongoing. The state will continue to utilize all available resources to investigate the case and bring a suspect or suspects to justice. To be clear, the state is not asserting at this time that the defendant is innocent. However, for all reasons set forth below, the state no longer has confidence in the integrity of the conviction. The state further contends that that it is in the interest of justice and fairness that these convictions be vacated and the defendant, at a minimum, be afforded a new trial at this time. The defense is aware that should this motion be granted, the state's decision to proceed with a new trial or ultimately enter a no prosequi to the charges is contingent upon the results of the ongoing investigative efforts. The state will be requesting that the defendant be released on his own recognizance pending the investigation, should this court grant the instant motion. Now, in 2018, the Baltimore City Police Lab tested various items for DNA through an agreement between the Office of the Attorney General and the defendant's previous counsel. The testing yielded mostly inconclusive DNA results or no DNA results. On March 10, 2022, the state and the defense filed a joint petition for post-conviction DNA testing of the victim's clothing. Specifically, the parties sought to have an independent lab test the clothing for touch DNA, which procedures were unavailable at the time of trial. The items being tested in 2022 were not previously tested in 2018, with the exception of the victim's fingernails. After consultation with DNA experts, the parties tested the items believed to most likely yield results for touch DNA. Those items were fingernails, fingernail clippers, pubic hairs, underwear, bra, and shirt. The rape kit was also tested for the presence of DNA. Trace levels male DNA was detected on the victim's right fingernail swabs, the right fingernail clippers, swabs and the victim's shirt swabs. The swabs from the right fingernail and shirt were analyzed with genotyping kit that marks male Y chromosomes STR DNA. However, no useful typing results were obtained from this analysis. Another shirt swab and the right hand fingernail clippers were not analyzed because it was determined that the amount of male DNA was so minimal that it would not produce any results. Only female DNA was recovered from pubic hairs, left hand fingernail swab, left hand fingernail clippers, swabs, anal swabs, vaginal swabs, bra swabs, and underwear swabs. The remaining items are currently being reviewed for further testing. The facts of this case have been exhaustively detailed in prior court opinions. For the purposes of this motion, the most pertinent facts are as follows. The victim, 18-year-old Heyman Lee, was last seen at Woodlawn High School on January 13, 1999, around 2:15 to 2:30 p.m. Weeks later, on February 9, 1999, her body was discovered buried in Leakin Park. The cause of death was manual strangulation. The investigation turned to the victim's ex-boyfriend, Adnan Syed, the defendant, as the suspect. The state's theory was that the relationship was on again, off again, and in December of 1998, Ms. Lee started a new relationship, angering the defendant. The main pieces of evidence implicating the defendant was the testimony of the cooperating co-defendant, Jay Wilds. Wilds testified basically to the following: that the defendant said he was going to kill the victim, that the defendant admitted to strangling the victim, that the defendant showed Wilds the body in the trunk of her car, and that Wild helped defendant bury the body in Leakin Park. Wilds also directed police to the victim's car on February 28th in the area of the 300 block of Edgewood Avenue in Baltimore City. The other piece of evidence came from the defendant's cell phone records. According to Wilds, the defendant lent him his cell phone and vehicle that day. The cell phone was in Wilds' possession at the time of the murder. Wilds and the defendant were together at the time of the burial around 7 o'clock p.m. The state relied upon billing records showing the phone was connected on incoming calls to cell towers, placing the defendant's phone in the vicinity of Leakin Park around 7 p.m. The state's contention was Wilds' testimony, coupled with the cell phone records, tied the defendant to the victim's burial site in Leakin Park. Wilds pled guilty to accessory after the fact on September 7, 1999. He testified against the defendant in February 2000. He was sentenced on July 6, 2000 to 5 years, all suspended with 2 years of probation. On February 25, 2000, a jury found the defendant guilty of the following offenses: first-degree murder, kidnapping, robbery, and false imprisonment. Judge Wanda K. Hurd was presiding. Judge Hurd imposed a total sentence of life plus 30 years. In an unreported opinion, the Court of Special Appeals affirmed his conviction on March 19, 2003. On May 28, 2010, the defendant filed a petition for post-conviction relief, petition number 10432, which he supplemented on June 27, 2010. In that petition, the defendant raised 9 allegations of ineffective assistance of trial, sentencing, and appellate counsel. The post-conviction court issued an order and memorandum on December 30, 2013, denying all the claims. The defendant filed an application for leave to appeal, specifically raising the issue of trials counsel, failure to investigate Asia McClain as a potential alibi witness, and failure to pursue a plea deal. After noting this application, the defendant supplemented his application and requested that the Court of Special Appeals remand the case for the post-conviction court to consider an affidavit from Ms. McClain. The request was granted on May 18, 2015. The Court of Special Appeals issued a limited remand in which it afforded defendant the opportunity to file a request to reopen the post-conviction proceedings in the circuit court. Upon remand, the defendant filed a request for the circuit court to consider a new and independent basis for his claim of ineffective assistance of counsel, as well as a purported Brady violation concerning the cell tower location evidence. The post-conviction court granted the request to reopen his post-conviction proceedings to review both of the aforementioned issues. Let's see. On June 30th, 2016, the post-conviction court denied relief of the issues of counsel's failure to investigate Ms. McClain as an alibi witness regarding the trial's counsel failure to challenge the cell tower location evidence. The post-conviction court reasoned that the trial counsel's failure to challenge the cell tower information was in fact deficient, and that the deficiency prejudiced the defendant. As a result, the post-conviction court vacated the convictions and granted the defendant a new trial. See the memorandum opinion 2, dated June 30th, 2016. The state appealed, and on March 29, 2018, the Court of Special Appeals held that the failure of trial counsel to call Ms. McClain as an alibi witness warranted a new trial. However, the court reversed the post-conviction court's holding on the cell phone tower because of cell phone tower evidence on the basis that the issue was not properly raised in the first post-conviction. Therefore, it was waived. On March 8th, 2019, the Court of Appeals reversed the Court of Special Appeals and held that Ms. McClain's testimony did not warrant a new trial. The court, however, agreed with the Court of Special Appeals that the cell phone tower issue was waived. Defendant timely filed a petition for writ of certiorari in the Supreme Court of the United States. The petition was denied on November 25, 2019, Syed versus Maryland. Legal requirements in 2019, the Maryland legislature passed blah, 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 to allow the state to file a motion to vacate a conviction. The bill went into effect on October 1st, 2019. The immediate effect of the bill allowed the state to vacate convictions in which the conviction relied heavily on testimony from a member of the Corrupt Gun Trace Task Force. The statute also allows broad application of any conviction in which new evidence is called into question the integrity of the conviction, or there has been newly discovered evidence that creates a substantial or significant probability that the result would have been different. Most recently, this office filed a motion to vacate in the case of the state versus Paul Madison. Okay, and we're not going to go into that, in which the defendant was convicted of second-degree murder. After a re-review of the case, the state filed a motion to vacate on the basis of defendant's conviction was based on uncorroborated testimony of a witness who was a jailhouse informant, who was promised benefit for an unrelated charge. The informants testified that she did not receive the benefit, which turned out to be untrue. Brady violations discovered in the state's trial file that the two alternative suspects were developed that were not disclosed to the defense. A new witness was advised who advised the state of new evidence regarding the details of the murder. The state asserted in the motion that it no longer has confidence in the integrity of the conviction and asserts that the interest of justice and fairness justified vacating the conviction. This honorable court granted that motion December 21st, 2021, and Mr. Madison was released from incarceration. The state can move to vacate a conviction pursuant to MD Code and Crim Procure. Okay. This is newly discovered evidence the court could have discovered by due diligence in time to move to a new trial under Maryland rule. Creates a substantial or significant probability that the result would have been different. The state's attorney received new information after the entry of a probation before judgment or judgment of conviction that calls into question the integrity of the conviction, and the interest of justice and fairness justifies vacating the probation before judgment or conviction. Although there is evidence in this case that would substantiate proceeding under various legal vehicles, based on the entirety of the information set forth below, the state will rely on provision. Based on the cumulative effect, all of the issues below involving new information and Brady violations, the state no longer has confidence in the integrity of the conviction. Additionally, the state asserts that the interest of justice and fairness dictate that the convictions be vacated and that the defendant be afforded a new trial at this time. Pursuant to criminal procedure article blah blah blah, defendant inmate number 293908, okay, blah blah blah, Jessup Road, Maryland, was advised of the filing. All documents were sent electronically to counsel. Defendant Erica J. Suter, pursuant to criminal blah blah blah, the state requests a hearing. The parties have developed evidence regarding the possible involvement of two alternative suspects. References to these two suspects will be mentioned throughout this motion as one of the suspects. The two suspects may be involved individually or may be involved together. These suspects were known persons at the time of the investigation of the case and not properly ruled out and set forth below. In the state's reinvestigation of this matter, new information was learned about these individuals that suggest motive and or propensity to commit this crime. However, in order to protect the integrity of the ongoing investigation, the names of the suspects, which suspects in particular, and the specific details of the information obtained will not be provided at this time. The state located a document in the state's trial file which provided details about one of the suspects. A person provided information to the state that one of the suspects had a motive to kill the victim, and that the suspect had threatened to kill the victim in the presence of another individual. The suspect said that he would make her, Ms. Lee, disappear. He would kill her. The state also located a separate document in the state's trial file in which a different person relayed information that could be viewed as a motive for that same suspect to harm the victim. The information about the threat and motives to harm could have provided a basis for the defense to present and or bolster a plausible alternative theory of the case at trial. And due to the ongoing investigation, further details of this information will not be provided at this time. The information was not contained in the defense's file, nor was it included in any of the various discovery pleadings the state produced each time it disclosed new information of the defense. Okay. The state's discovery obligations in circuit court criminal cases requires the state's attorney disclose without request any material or information tending to negate or mitigate the guilt or punishment of the defendant as to the offense charged. Additionally, another rule, special duties of a prosecutor, provides that a prosecutor shall make timely disclosures to the defense of all evidence known to the prosecutor and tends to negate the guilt of the accused or mitigates the offense. Further, the duty to disclose applies to disclosures post-conviction, Attorney Grievance Commission of Maryland versus Caselli, okay? To prevail on a Brady claim, the defendant must plead and prove that the prosecution suppressed evidence. The evidence was favorable to the defendant either as to guilt or punishment, and evidence was material to the issue of guilt or punishment. The failure to turn over information regarding an alternate suspect can constitute a reversible Brady rights violated when the government did not disclose evidence pointing to an alternative suspect. Okay. The state avers that considering the totality of the evidence now available, the information about an alternate suspect would have been helpful to the defense because it would have helped them substantiate an alternative suspect defense that was consistent with the defense strategy at trial. Additionally, the evidence against the defendant was not overwhelming and was largely circumstantial. Therefore, evidence such as an alternative suspect tends to carry more weight in the analysis. The Court of Special Appeals summarized the concerns. The state's case was weakest when it came to the time it theorized that Syed killed Hay. As the post-conviction court highlighted in its opinions, Wild's own testimony conflicted with the state's timeline of the murder. Moreover, there was no video surveillance outside the Best Buy parking lot placing Hay and Syed together at the Best Buy parking lot during the afternoon of the murder. No eyewitness testimony placing Syed and Hay together leaving the school or at the Best Buy parking lot, and no eyewitness testimony, video surveillance, or confession of the actual murder. No forensic evidence that linked Syed to the act of strangling Hay or putting Hay's body in the trunk of her car, and no records from the Best Buy payphone documenting a call to Syed's cell phone. In short, at trial, the state adduced no direct evidence at the time that Hay was killed, the location where she was killed, the acts of the killer immediately before and after Hay was strangled, and of course the identity of the person who killed Hay. Accordingly, it is the state's position that the alternative suspect information above, which contained an actual threat and plausible motive, was material. Had this information been disclosed, defense counsel would have had a duty to investigate, and it could have enhanced the alternative suspect defense. New evidence. The location of the victim's car was located directly behind the house of one of the suspect's family members. Ms. Lee's car was found parked in a grassy lot behind the 300 block of Edgewood Avenue in Baltimore City. Through investigation of property records and other media, it has been determined the location was known to one of the suspects. A person related to the family owned a house on the 300 block of Edgewood Road for many years, and that person lived at that location in 1999. The state uncovered this information during an investigation in 2022. This information was not available to the defendant in his trial in 2000, and the state believes it would have provided persuasive support substantiating the defense that another person was responsible for the victim's death. New information. One of the suspects, without provocation or excuse, attacked a woman in her vehicle. The defense located formally documented evidence unavailable at the time of the trial that one of the suspects had, without provocation or excuse, attacked a woman unknown to him while she was in her vehicle. The suspect was convicted of this offense. The information was not available at the time of trial and occurred after the trial. However, the state finds the information relevant and worthy of further investigation now that it is assessing the possible involvement of the suspect. In order to protect the ongoing investigation, the parties are not able to reveal specifics at this time. New information. One of the suspects engaged in serial R and sexual assault. The state and defense have obtained credible information that one of the suspects had engaged in multiple instances of R and SA of compromised or vulnerable victims in a systematic, deliberate, and premeditated way. The suspect was convicted of this offense. You're having issues, Petty Patty, with the chat? I don't know. What's wrong? What kind of issues are you having? The information was not available at the time of the trial and occurred after the trial. However, the state finds the information relevant and worthy of further investigation. Now that it is assessing the possible involvement of the suspect, in order to protect the ongoing investigation, parties are not able to reveal specifics at this time. However, the state finds the information credible. New information. One of the suspects engaged in violence against a woman known to him. The defense located formally documented evidence of allegations that one of the suspects had engaged in aggressive or violent acts towards a woman known to him and forcibly confined her. It was also alleged that this suspect made threats against the life of this person. And these events happened prior to the trial in this case, and the information was known to the state. And given the circumstances of the victim's death, this evidence would have been consequential to the defense's theory of this case. In order to protect the ongoing investigation, the parties are not able to reveal specifics at this time. F. New evidence. One of the suspects was improperly cleared as a suspect. The police initially developed one of the suspects and administered a standard polygraph test. The results were that deception was indicated regarding his involvement in that crime. The suspect claimed he was distracted, so the police allowed him to come back the next day and take a second test. The state consulted an expert who reviewed both polygraph tests and the results, according to Donald J. Krapol of the Capital Center for Credibility Assessment. Modern polygraph techniques, including the one in the suspect's examination, have built-in safeguards against a range of potential contaminations of the test data. In the case of distracted examinee, test results would tend to be shifted towards the direction of inconclusive rather than towards deception or truthfulness. And therefore, the testing examiner's suggestion that distraction played a part in the test results of deception indicated would not be consistent with either prevailing evidence or theory. It would not be normal practice to base a recommendation for a retest under the circumstances described in the polygraph report. Emphasis added. Even more concerning is that the police then improperly cleared the suspect after applying a second test, which was a test that should have never been used to determine deception or truthfulness. The second test was a peak of tension, POT test. Regarding this test, Mr. Krapol determined that a peak of tension test should not be used to disinform a deception test. He concluded, no schools in the U.S. teach the POT as a primary technique. Its validity is not well established. Moreover, it has no scoring system, but relies instead on subjective interpretations of overall trends in the polygraph tracings. Example, the blood pressure continues to climb across the entire test until the presentation of the guilty item, after which the pressure shows a downward trend. This reviewer is not aware of any U.S. school that would support a polygraph test of deception indicated or no deception indicated when a POT was employed as a standalone test. The test results reported in the session were no deception indicated. As such, it places the examiner's conclusion firmly outside of a standard polygraph practice. Emphasis added. In conclusion, Mr. Krapol found within the limits of the information available, the reviewer would not support the testing examiner's assertion that the first test results were influenced by the examiner's distraction, nor that a decision or no deception indicated can be defended in the second examination. The police relayed to the prosecution that this suspect passed the second test with flying colors. However, Mr. Krapol's affidavit strongly calls the veracity of the conclusion into question, inasmuch as the second test was neither supported by the professional or academic communities, nor methodologically sound in its application. There was no further investigation of this suspect after the second test. The state contends that the Brady violations alone would substantiate the granting of a new trial. The new evidence regarding the possible involvement of alternative suspects gives the state great concern. But considering the seriousness of this case and the importance of holding the right suspects accountable, the state also extensively reviewed the evidence presented at the first trial and notes several additional concerns below to demonstrate why it is no longer had faith in the integrity of the conviction. The state cannot rely on the incoming call evidence based on the post-conviction court's findings. The state relied on billing location information provided by AT&T to account for the whereabouts of the defendant's cell phone on January 13th. There's an Exhibit 4, call records. This information was critical to the state's case because it corroborated some of Jay Wilde's testimony regarding the whereabouts throughout the day. However, the notice of the record specifically advised that the billing locations for incoming calls would not be considered reliable information for location. Despite this notice, the state used the billing location for incoming calls for exactly that purpose, to prove that the defendant was in a particular area at a particular time most critical to the state's case, and were the incoming calls allegedly received in the Leakin Park area at 7:09 p.m. and 7:16 p.m. Moreover, 11 of those 34 calls billed on January 13th were incoming calls. Defense counsel M. Cristina Gutierrez seemingly did not realize the importance of this information, or did not see it at all, and therefore did not cross-examine the state's cell phone tower expert regarding this information, this limitation. The post-conviction court found that the notice was in her trial file, so it did not constitute a Brady violation. And additionally, the state's expert, Adam Woronowitz, subsequently expressed concern over his testimony of the incoming call location status. It is in a signed affidavit. Woronowitz stated that the state did not show him the notice language, and had he seen it before his testimony, he would not have testified that the location evidence was accurate. And then there's Exhibit 5, Woronowitz affidavit from 10/5/2005. He later supplemented the affidavit in 2016, stating that he interpreted AT&T's legend to most likely apply to both PC at 215 and Exhibit B, and location status to apply to cell phone tower locations. If his assessment regarding the legend was true, that would mean the incoming calls were reliably attached to that specific cell phone tower. The issue was raised in the defendant's supplemental post-conviction petition that the Honorable Martin Welch, in Memorandum Opinion 2, made several findings regarding the testimony of the state's expert and the testimony of the defense expert. The state's expert testified that the legend applied only to subscriber activity reports and would not apply to call detail records. The post-conviction court found that the instructions did not apply to the records, and the witness abandoned his initial position. The witness also testified that the term location meant the location of the switch, identified by location 1 column, and surmised that the legend meant the information was not reliable for determining the location of the switch. The post-conviction court concluded that the witness contradicted his own testimony that the term location referred to the switch location and not the cell site. In its ruling, post-conviction court found that the trial counsel rendered deficient performance when she failed to properly cross-examine Woronowitz about the disclaimer. The court also found that a reasonable attorney would have exposed the misleading nature of the state's theory by cross-examining Woronowitz, and that this failure can hardly be considered a strategic decision. Just hang on one second, because I have to get a cracker or something, because I took a bunch of vitamins and I'm feeling like weird. So let me get something. I'll be right back. Gotta get just a cracker or something. What's wrong, Patty? What happened to Patty? So I had another appointment with the ophthalmologist regarding the shingles. I may have a permanent droop. Oh no. Well, I'll tell you something, Petty Patty. It doesn't mean that that's the way it is, because I've told people before this, an orthopedic surgeon told me I would never again have control of my hand, that I would have a claw with these two fingers, and if I didn't have my ulnar nerve transpositioned, that I would definitely never be able to have any chance to have control and the nerves to be regenerated. He also told me that with the surgery, he didn't think I would ever be able to have full use of this hand again. Okay? He called someone else in the room to come look at it. Long story short, I went for a second opinion to a doctor up in Valhalla, which is one of the best places you can go in New York. And she told me that nerves are funny things, and they can regenerate on their own. They can do things that they don't even know. She scheduled me for the surgery and all that. As soon as she gave me that little bit of hope, I started to do stuff with the hand, and all of this is back without the surgery that he said. So they're not gods, so don't get so caught up in that. Go for another opinion. I don't assign yourself that it's the worst. That's what I'm going to tell you. There's also a saying that something like, don't ever underestimate what just a little hope can do. So don't let them bring you down. Hey, Marianne Frantini. Sorry about your daughter, too. A little hope. Really, get a second opinion. Don't. Uh-oh, lip cancer? What? Oh no, Marianne. I hope she's okay. What's the prognosis? Prayer she's okay. Go to a very good doctor, Petty Patty, the best that you can go to. Oh, good night, Earthbound. I feel better. I just have to finish this cracker and then I can go on. Okay. Oh, well, we'll keep her in our prayers, Marianne. Prayers that she has a wonderful prognosis and a full recovery. Amen. The post-conviction court found that this failure satisfied the second prong of the ineffective assistance of counsel analysis. The court wrote, trial counsel failed to confront the state cell tower expert with a disclaimer and thereby allowed the jury to deliberate with the misleading impression that the state used reliable information to approximate the general location of the defendant's cell phone during the time of the burial. The jury likely gave considerable weight to Waranowitz's testimony, and the incoming calls during the time of the burial served as the foundation of the state's case. Accordingly, the court found that but for trial counsel's error, the result of the trial was fundamentally unreliable. The court further stated, although the court's ultimate finding does not depend solely on Rwanowitz's affidavit, the affidavit casts an additional fog of uncertainty that shakes the court's confidence in the outcome of the trial. The post-conviction court granted defendant a new trial on this allegation. However, the Court of Special Appeals overturned the decision, finding that the issue was waived because defendant did not previously raise this issue in his first post-conviction petition, Syed versus State. The Court of Appeals upheld the ruling on waiver. Syed, State versus Syed, 463 Maryland, 6103 to 104, 2019. Based on the post-conviction court's lengthy assessment of the issue and its findings, the state's confidence in the reliability of the incoming calls is also shaken. Accordingly, in an effort to obtain more information regarding the actual reliability of the incoming calls, the parties consulted with the defense's expert, Gerald Grant, who is a digital forensics investigator with expertise in computer forensics, mobile forensics, and historic cell site analysis. Mr. Grant explained the following regarding incoming and outgoing calls. When a mobile device makes an outgoing call, the device itself chooses the tower sector to utilize based on the cleanest, clearest, strongest signal at that time. Once an outgoing call is in session, the cellular network system controls what tower the device uses or gets transferred to, handoff. An incoming call to a mobile device may have the communications signal sent to multiple towers in an area to notify the device of the call. In other words, the network cannot guarantee at the time of the incoming call that it knows exactly what tower sector the device is listening on. Based on the cellular technology at the time of the incident in this case, I am aware that AT&T utilized a communication technique called TDMA, Time Division Multiple Access. This communication protocol allowed a mobile device to operate in sleep mode to conserve on batteries. And based on how a mobile device was located on an incoming call, a function like this could be one of the reasons a disclaimer was necessary. For example, it is possible that an incoming call could be recorded at the last registered tower sector and not the current one when the signal is sent across multiple towers within an area. Hi, LMNW. Okay, now, the state proffers it has consulted two additional non-trial expert witnesses whose expertise, including advising the government on the development, setup, and the operation of cellular networks and the operational use of the Global System for Mobile Communications, GSM, to track and locate cell phones. And after reviewing the cell phone data documents in this case, these experts each individually called the reliability of the state's testimony at trial into question, because the information regarding the tower and the sector associated with the cell phone of an incoming call cannot be conclusively ascertained with the information that was adduced at the trial. Both experts substantiated Grant's conclusion that incoming calls could plausibly be associated with a tower and sector that was not most proximate to the location of the phone at the time of the incoming call. One of the experts explained, doing surveys from the ground, we could always see 3 to 5 towers, sometimes more. Any tower could service the call. It does not have to be the closest or strongest signal, but enough power for errors to be overcome with the coding gain afforded by the network. It was therefore overly prejudicial to allow evidence of this sort at trial. Okay. Upon review of the totality of the information now at the state's disposal, the state does not believe the incoming call location evidence is reliable. The assessment must, therefore, turn to whether the testimony of the co-defendant, Jay Wilds, in and of itself restores confidence in the state's case against the defendant. New information that Christina Vinson's version of events was incorrect. The testimony of Christina Vinson, who was used to corroborate Jay Wilds' version of events, she testified that on the afternoon of January 13th, the date of the murder, she got home at 5 to 5:15 p.m. Wilds and the defendant came to her home around 6 p.m. Defendant got an incoming call on his cell phone and quickly left. She remembered that date because she had an all-day conference. At the first trial, Vincent testified that it was not until her interview with police on March 9th that she had to recall the date in which Wilds and the defendant came to her home. During that interview, she told police she had gotten home around 4:30 to 5. In the HBO 2019 documentary, The Case Against Adnan Syed, Ms. Vinson was presented with a copy of her winter schedule at UMBC, which reflected that she had an evening class scheduled for January 13th. The class met a total of 3 times, and Ms. Vinson indicated that she would have not missed a class. The new evidence tends to show that Ms. Vinson was incorrect about her recollection that Wilds and the defendant visited her on January 13th, thus calling into question the portion of Wilds' testimony, which is that he and the defendant went to her home on January 13th. The state cannot rely on Jay Wilds' testimony alone. Relying on Jay Wilds' testimony in and of itself is a concern for the state. Indeed, the original prosecutor in this case shared the same concern. Jay's testimony by itself would have been proof beyond a reasonable doubt? Probably not. Cell phone evidence by itself? Probably not. Detective McGilvary reconfirmed that Wilds' statements to police had a lot of inconsistencies and regarded them as lies. He testified that the cell site information did not correspond with Wilds' story and that he initially told police. So when presented with that cell records during the next interview, he started to recall things a little better, and they took a second statement. It was also during the second interview that Wilds allegedly told police about the location of the victim's car. The detective stated on the recording that Wilds gave them the information of where the car was located before they turned the recorder back on when they were flipping the tape over. Wilds otherwise did not request that the recorder be turned off, and he was not refusing to talk. Police interviewed Wilds again March 15, 2022 to clear up discrepancies and recorded the interview. They interviewed him a 4th time on April 13th, but did not record the interview or take notes. The state has considered all the various statements to police that were recorded. The trial testimony at both trials and Wilds' subsequent statements to various media outlets. For the purposes of this motion, the state will highlight the most concerning discrepancies. The post-conviction court detailed several instances of discrepancies between Wilds' testimony, the cell phone records, and the state's timeline. For example, the state's theory is that the victim was killed sometime after school and defendant called Wilds to pick him up at the Best Buy at 2:36 p.m. However, Wilds testified the defendant did not call him until after 3:45 p.m., altering the state's timeline significantly. Additionally, Wilds gave 2 different accounts to the police about where he saw the victim's body, and he gave a 3rd account to media. At his February 28, 1999 interview with the police, he told them that he saw the body in the trunk on Edmondson Avenue. And during the March 15th, 1999 interview, he told police it was at the Best Buy. And he lied about the Edmondson location because he did not want to be associated with the Best Buy location where the murder occurred. Wilds then claimed in a 2014 interview that he saw the body at his grandmother's house. but thinks he told the police he saw the body in front of Kathy's house. Even more bizarre, Wilds claimed that he picked up the defendant at the Best Buy, but that the victim and the car stayed at Best Buy until later that evening. At some point, the defendant gets into his car and then comes back in a different car with the body in the trunk. For all of these reasons stated above, without reliable corroboration, the state cannot rely on Wilds' testimony alone at this time. Detective William Ritz passed misconduct. The two homicide detectives who investigated this case were Detective William Ritz and Detective Greg McGilvary. The state does not make any claims at this time regarding the integrity of the police investigation. However, in the interest of transparency, the state is obligated to note for the court as to the defense Detective Ritz's misconduct in another case, the State versus Malcolm Bryant, which resulted in an exoneration in 2016. Malcolm Bryant was wrongfully convicted of murder in 1999. He served 17 years before his exoneration. In the Bryant case, it was alleged in the complaint that Detective Ritz failed to disclose exculpatory and impeachment evidence and fabricated evidence. More specifically, it was alleged that Detective Ritz obtained misidentification of Mr. Bryant from Taisha Powell, the single eyewitness presented at trial. Detective Ritz failed to disclose evidence about a second eyewitness whose account contradicted and undermined Taisha Powell. He also failed to disclose incriminating evidence pointing to the likely true perpetrator, John Doe, including a witness statement incriminating Doe and undermining his denials of culpability, and a composite sketch that more closely resembled Doe than Mr. Bryant. Plaintiffs claim that when Detective Ritz met with Ms. Powell and another detective to create a composite sketch of the suspect, Detective Ritz used direct or indirect suggestion to manipulate the composite sketch to make it look to more closely resemble the person he suspected, Malcolm Bryant. Plaintiffs also claim that Detective Ritz showed Ms. Powell a suggestive photographic lineup consisting of 6 individuals, including Malcolm Bryant. In addition to the alleged misconduct during Ms. Powell's interview, plaintiffs claim that Detective Ritz never interviewed or conducted any follow-up investigation with any of the individuals with whom Mr. Bryant had spent the evening of November 20th, who could have provided an alibi for him. Detective Ritz was also allegedly failed to investigate other evidence of Bryant's whereabouts on the night of the murder. Additionally, plaintiffs allege Detective Ritz did not disclose to Mr. Bryant's counsel, or the prosecutor some of the evidence he obtained that incriminated another suspect, and he did not conduct proper interviews about or of the suspect. Plaintiffs also allege that police received 3 911 calls on the night of the murder, one of which was from a potential eyewitness whose account of the crime contraindicated Ms. Powell's account. Plaintiffs claim Detective Ritz did not investigate the potential witness's report and never discussed the report of the second potential eyewitness or the other 911 calls to Mr. Bryant, Mr. Bryant's counsel, or the prosecution. Plaintiffs also claim the defendants never tested critical items of evidence obtained from the crime scene for DNA, which would have exonerated Mr. Bryant. The estate of Malcolm Bryant sued the Baltimore Police Department Detective William Ritz and forensic analyst Barry Verger in 2019 for the wrongful conviction. In 2022, Baltimore City's Board of Estimates approved an $8 million settlement to the Bryant estate. In a separate and unrelated case, the Court of Special Appeals overturned another murder conviction due to Detective Ritz's 2-step interrogation technique, which was improperly used in a calculated way to undermine the defendant's Miranda's warning. See Cooper v. State, 2005. Conclusion. It is the policy of the state's attorney for Baltimore City to prioritize justice, fairness, and the integrity of the criminal justice system over the finality of convictions. Recent history has unfortunately revealed systemic issues in the arrests and investigations and prosecutions of minorities in Baltimore. These concerns can plague the credibility of some past convictions, which occasionally necessitates looking at cases where newly discovered or additional evidence suggests the wrong person has been convicted. In these rare cases, the state is morally compelled to take affirmative action where it has lost confidence in the integrity of a conviction. The instant case is one in which an abundance of issues that give the state overwhelming cause for concern. The state's Brady violations robbed the defendant of information that would have bolstered his investigation and argument that someone else was responsible for the victim's death. The impact of the Brady violations was amplified by the ineffective assistance of counsel throughout this case regarding the reliability of the cell phone evidence. Additionally, there are concerns highlighted by the new information regarding alternative suspects and new evidence regarding the reliability of critical evidence at trial has caused the state to lose confidence in the integrity of the conviction. The state further asserts that it is in the interest of justice and fairness that the defendant, at a minimum, be afforded a new trial at this time. The state also prays the defendant be released on his own recognizance, pending the continued investigation. The state intends to continue with all available resources to fully and thoroughly reinvestigate this matter to ensure accountability and justice for the victim, Ms. Lee. However, the state submits the continued incarceration of the defendant while the investigation of the case proceeds, considering all of the information above, would be a miscarriage of justice. Wherefore, the state prays that this honorable court grant a hearing in the matter, and that following a hearing, this honorable court pass an order vacating the judgment in this case and order a new trial, and c. grant any other relief as fundamental fairness may require. Respectfully submitted, Marilyn J. Mosby, the State Attorney for Baltimore City, and it's signed by Becky Feldman, Assistant State Attorney. I hereby certify that on September 15, 2022, Jimmy's birthday, I emailed a copy of the foregoing motion to Defense Counsel Eric Suter. Okay, so, yeah. Wow. Hello, Scooter. Okay. So, let me just see something else here. Let me see something here. So this is Jay Wilds, and this is the man that we were reading those interviews with last night. He's a former classmate of Adnan Syed. Right, we heard all those interviews, and he was the state's witness, but now we see there's a lot of problems with that, right? Yes, lots of problems. Lots of problems. Someone says, if Syed's freedom is a cause for celebration, it is also a cause for shame. He was not released because the American criminal justice system is fair. He was released despite its brokenness and corruption. For years, he remained in prison despite the worldwide attention brought by the Serial podcast and the relentless efforts of a core group of stubborn advocates. In the end, it took a random and quirky turn of events to unshackle him. Because of the Serial podcast, the world has known that Syed's conviction rested on shaky ground. The host of the podcast, Sarah Boone, documented how Syed's trial attorney fell down on the job by failing to call a crucial alibi witness to stand or to challenge the accuracy of the cell phone records at the heart of the state's case, which came with a cover sheet stating any incoming calls will not be reliable information for location, which we just heard in the the order to vacate. The overturning of Adnan Syed's conviction came about accidentally. His petition was reviewed by Becky Feldman, the new head of the prosecutor's resentencing unit, who previously spent more than 10 years as a public defender. And because Feldman re-examined the entire case file, she discovered the long-buried evidence and turned it over. And it was only then that the state finally admitted that Syed's conviction could not stand. The state of Maryland has not given up. Syed has been released but confined to home with an electronic monitor that tracks his every movement. Prosecutors are still considering whether they want to retry him. While abhorrent, this is not an aberration. This is how our legal system was designed. So, okay. Let's see what else we have. So, yeah, I mean, interesting stuff. Let's see who's here. And gallery. Hello, everyone.
Hello.
Hello. I am at my mom's place. She's buying something yummy for you, Jeanette? That's great.
Hello.
Hi, Sharon. So, So it sounds like, I don't know, it sounds like the more you look at, he shouldn't have been in there. They really didn't have a strong case at all.
Yeah, this case is definitely not without its problems.
No. So I don't think they'll retry it again either. I believe that
No.
they're not going to. And I don't know that
think
they'll
so.
ever get anybody else. So we shall see. Anybody have any thoughts in the chat? Oh, you know what? Let's look at the, just quit real quick. I was watching a little bit of the Alex Jones today, but like I said, I was on the road most of the time, so I have to play some catch up on that. But I just wanted to see if there was, there's an update on that poor mother that was killed. Put her up here. This mother right here that we read about the other day.
With the blonde hair?
Yeah.
Yeah.
Police incident report has shed more light on the mysterious death of a Georgia mom who was found deceased last week in Clarksville. On September 10th, 59-year-old Debbie Collier sent her daughter $2,385 using Venmo. It included a message that read, "They are not going to let me go. Love you." After receiving the message, Debbie's daughter tried to call her mother but could not get through. Worried, her daughter contacted the police and reported her mother missing. Investigators determined that Debbie Collier left her house with only her driver's license and a debit card. Last Sunday, police tracked down a rental vehicle that Collier was using to a wooded area 60 miles away from the family home. Police scoured the vicinity of the vehicle and they found her body in a nearby ravine. Now, when investigators descended onto the scene, they were joined by multiple family members of the Collier family, including her husband. He told police that he last saw his wife at about 9 p.m. on Friday, September 9th, as he was going to bed. The husband went to work on Saturday morning and told investigators that his wife's vehicle was still in the driveway at that time. Collier's husband reportedly said that she was sleeping in a different bedroom that night before she disappeared due to his snoring. Okay. And let's see, here's a... here's what it says on the incident report. So it says, on Sunday, September 11th, 2022, at approximately 12:28, Sergeant Ethan Neal was notified by 911 dispatch that a caller from Sirius XM service had been pinging a vehicle per the request of Athens Clarke County Police Department in reference to attempting locating a missing person. The caller from Sirius XM advised dispatch that they had been attempting to locate the vehicle and believed that it might have stopped or pulled over in the area of Georgia 15 northbound in the area of Victory Home Lane, Clarksville, Georgia. The vehicle was identified as a 2022 Chrysler Pacifica, black in color, with a Georgia tag, and gives the number. The missing person was identified as Deborah Todd Collier. Her date of birth, September 2nd, 1963. Sergeant Neal requested, so she would be 59. Okay. Requested Officer Dakota Foster from the Tallulah Falls Police Department to be en route to the area to attempt to make contact. At a short time later, Sergeant Neal was notified by Foster that he had located the vehicle. While en route, Sergeant Neal contacted the Athens Clarke County Police Department, spoke with Sergeant Johnson. Johnson advised Sergeant Neal that circumstances of the missing persons incident and informed him that they had been attempting to ping Collier's cell phone throughout the night. Johnson also advised Sergeant Neal that the last communication that Collier had was to her daughter, and he advised that Collier had used Venmo to send approximately $2,300 to her daughter with a message that stated something to the effect that "they won't let me go. There's a key to the house underneath the flower pot." Upon Sergeant Neal's arrival, he observed the vehicle parked in what appeared to be a pull-off that leads to an old logging road directly off of GA 15 northbound. Prior to Victory Home Lane, Sergeant Neal was notified by Foster that he observed the vehicle in the same spot at approximately 1700 hours on September 10th, but informed Sergeant Neal that vehicles routinely pull off in this area. Foster also advised Sergeant Neal that the vehicle was unlocked and unoccupied. Foster also stated that he walked into the woodline a short distance to see if he could immediately locate Collier, but was unable to do so. Sergeant Neal requested Lee Arundel Correctional Institute K-9, Lacey K-9, to be en route to the scene, and Sergeant Neal also requested Georgia State Patrol Aviation, GSP Aviation, to be en route. A short time later, dispatch informed Sergeant Neal that Lacey was unable to respond due to the unavailability of a K-9 and was advised that GSP Aviation would be en route. Sergeant Neal requested Deputy Blake Forrester to be en route to attempt to locate Collier. While on scene, awaiting the arrival a Forrester, Collier's daughter, Amanda Bearden, arrived on the scene in a hysterical state. Amanda began screaming that the vehicle belonged to her mother. Amanda was notified by Athen Clark County PD that the vehicle was being pinged by Sirius XM and provided her with the approximate location of the latest ping. Sergeant Neal and Foster spoke briefly with Amanda, asking general questions in reference to Collier's mental health state and briefly about her medical history. Amanda advised Sergeant Neal and Foster that her mother did not have any history of mental health issues and denied any suicidal tendencies. She also stated that her mother had a bad back and could not walk far. While speaking with Amanda, Forrester arrived on scene. Sergeant Neal briefed Forrester on the incident and requested that he deploy his K-9 to attempt to locate Collier. Forrester deployed his K-9 and began searching for Collier, accompanied by Sergeant Neal and Foster. During the track, Sergeant Neal allowed Foster to stay approximately 25 to 30 feet ahead of him, while he and Foster scanned the woods for any signs of Collier. As Foster proceeded southeast through the woods, Foster called out to Sergeant Neal that he had located an item. Sergeant Neal and Foster quickly approached. Sergeant Neal observed a red tote bag laid on its side near an uprooted tree. At the root ball of the tree, Sergeant Neal observed what appeared to be the remains of a fire. As Sergeant Neal approached the fire, he looked further down the embankment. Sergeant Neal observed what appeared to be a partially burnt blue in color tarp. As he looked further down the embankment from the tarp, he observed a nude female lying on her back, grasping a small tree with her right hand. Sergeant Neal approached the female, immediately observing her to be obviously deceased and identifying her as Collier. Sergeant Neal observed Collier's remains to be apparently burnt with what appeared to be charring to her abdomen. Sergeant Neal instructed Forrester to hold the immediate area while he returned to his patrol vehicle to make the appropriate calls for assistance and to establish a crime scene. Sergeant Neal returned to his patrol vehicle, established a crime scene using crime scene tape around the immediate area of the vehicle, and began a crime scene log at 15:06 hours. At this time, Corporal Andrew Townsend arrived on scene and took over maintenance of the crime scene for the duration of this incident. Sergeant Neal contacted the Habersham County Sheriff's Office Criminal Investigations Division investigator George Kaysen and requested his response to the scene. Sergeant Neal also requested that the State Fire Marshal's Office agent Brian Smith be en route to the scene. A short while later, Carson, along with the investigator Cal Garrison and crime scene Kayla Neal, arrived on scene. Technician. The scene was turned over to Kaysen, Garrison, and crime scene technician Neal. Sergeant Neal requested that, that's funny, they both have, I wonder if they're related, they both have the same last name, Kayla Neal and Ethan Neal. Requested next list worker RJ's Wrecker Service to be en route to remove the vehicle. Upon completion of the initial investigation at the scene, Collier's remains were collected by Coroner Keith Franklin with assistance from the Habersham County Fire and EMS personnel. RJ Wrecker Service removed the vehicle. Sergeant Neal followed RJ Wrecker Service from the scene to the Habersham County Sheriff's Office, and the vehicle was placed into evidence. Sergeant Neal returned to service. Hold on, so it says here, let's see. I guess that's pretty weird. So her body was partially burnt. That's not good, but who did it? I mean, we don't know who, any suspects or anything yet. It's crazy. TikToker's mom who chronicled sick daughters was actively. Oh, great. Okay, TikTok again is turning into a great place over here. A Pennsylvania woman who posted on social media about her 10-year-old daughter's various medical issues was arrested last month for allegedly prolonging her recovery, presumably to garner funds. Oh, okay. Another scammer? After the victim had back surgery a few years ago, her mother, Yvette Brady, 31, allegedly prevented the incision from healing. It caused the girl to undergo more surgeries, and doctors were suspicious for a while as the girl's surgical incision would heal while in the hospital or under home health nurses' supervision, but healing would stop while in Brady's care. In June, Lackawanna County investigators contacted the hospital physicians regarding the suspected medical abuse. They reportedly described an ordeal that involved faking, exaggerating, and even causing the child's symptoms. The girl told police in July that Brady coached her on what to say to them. She reportedly also stated that her mother is unemployed and supported herself through donations, including a GoFundMe page, that was established for the girl's medical recovery. The mother allegedly also documented her daughter's medical complications and recovery on TikTok and Facebook. Brady is charged with endangering the welfare of a child and simple assault, and on Monday she waived her right to a preliminary hearing. Great. That's just great. Okay, now let's see what this is about. Three people were arrested in Texas this week and charged with the murder of a teen who was found dead on the side of a rural Liberty County road earlier this month. Emily Rodriguez Avila was found dead on September 4th, a day after texting family members to say a friend was giving her a ride home from work. Still wearing her work uniform, the 16-year-old's body had been dumped beside the road about an hour away from her job at Nico Greek restaurant. The Liberty County Sheriff's Office arrested Kevin Rivera Ortiz, 19, Catherine Alvarez Flores, 20, and Joel Garcia Martinez, 20. Investigators say Rivera Ortiz and Rodriguez Avila's ex-boyfriend. Okay, so Rivera Ortiz was Catherine. No, what do you mean? Hold on a minute. Oh, was hold on a minute. Let me see here. Okay, so the woman, the teenager, the 16-year-old that was killed. This one here was her ex-boyfriend. No. Yes. And this one also faces a tampering charge, the woman here. Okay. While the two men arrested with the assistance of gangs units from the Houston Police Department and U.S. Homeland Security. Okay, they face a tampering thing. All three have been booked into the Liberty County Jail on $1 million bonds each. Last week, Nico's held a fundraiser to help Rodriguez Avila's family with funeral expenses. The family hopes to bury her in Honduras, where she was born. Wow, that's sad. Okay. Here's a great boyfriend. This is stranger and stranger. An East Tennessee man has been charged with using a blowtorch on his girlfriend. and barricading the door of their home to trap her inside. The Carter County Sheriff's Office said they received a domestic violence call on Tuesday. They found a woman who said her boyfriend had been abusing her for months and had held her against her will and would not let her kept her from leaving by using objects to barricade the front door. Deputies noticed that the woman's hands were red and they were swollen with several abrasions, and when she raised her sleeves, they noted she had several burn marks along with lacerations. She said the burn marks were caused by a blowtorch he had burned her with. Nice. She also displayed several bruises and lacerations on both sides of her legs and on her back. The woman identified her boyfriend as Thomas Neil Williams, and as deputies were talking with her, Williams came out of the house, got into a car, drove away. Deputies arrested him at a traffic stop a half a mile away. The woman told deputies that Williams used weather stripping and a weight bench to barricade the front door. The deputies observed screw holes in the wall and the door of the residence consistent with the weather stripping being used as a locking mechanism, and abrasion damage to the door consistent with the weight bench being propped up against it. Williams, 30, has been charged with aggravated assault as domestic violence and false imprisonment. He is being held on $20,000 bond, according to jail records. Great. An Illinois woman is facing attempted murder and battery charges after police say she pushed her 3-year-old nephew off a Navy pier at Lake Michigan. The incident happened at around 1 p.m. Monday, close to the 700 block of East Grand Avenue. Security footage reportedly captured the incident as Victoria Moreno, 34, pushed the child, identified as Josiah Brown, into the water and made no attempts to rescue him. Fire officials say the child was taken to Lurie Children's Hospital in cardiac arrest, and he has been placed on a ventilator and is not expected to live. Police added that the child had lung bleeding, a swollen brain, and had to have a heart infusion. This is unbelievable. Bail has been denied for Moreno. Judge Susana Ortiz heard arguments that Moreno suffers from a mental health condition, but Ortiz called the act intentional, brutal, and heinous. The judge also heard the details of the day in question and how Moreno stole the keys to the family truck before sneaking out of the residence without anyone knowing she had left. The state attorney, Lorraine Scaduto, said. Scaduto added that Moreno wasn't allowed to drive because of her mental health issue, and after she allegedly drove off last week with a group full of children, and that caused an alarming incident. During the latest incident, Moreno initially wanted to take her nephew to an aquarium and then reportedly decided against it. Instead, she took him to get fast food at Navy Pier. Scaduto said the boy wandered in the street afterwards and almost got hit by a car. In response, Moreno allegedly grabbed Josiah's hand and began walking near the water. The boy broke away and went to the edge of the pier, which drops 6 feet down into the water. He was reportedly on all fours under the chain at the platform's edge. The defendant looked around her multiple times and waited for people to leave, and looking around once again when no one was present, she allowed the 3-year-old child to crawl back under the chain towards the edge of the platform, doing nothing, Scaduto said. Once Josiah was under the chain again, Moreno allegedly straddled the platform and then used both hands to push the boy into the water. And not once during any of these events did the defendant scream for help. Did she call for help, ask for help, or try to help? When the police arrived, the defendant pretended not to know anything about the child. About 30 minutes later, first responders pulled Josiah from the bottom of the lake. It is not likely that he will survive these extensive injuries. Moreno is facing attempted first-degree murder and aggravated battery to a child. She has been assigned a public defender. Wow. That's incredible. Poor family, poor kid. An 8-month-old Florida infant died Tuesday after she was reportedly left inside a hot vehicle, marking the 29th hot death involving children this year. Sergeant Silcox with the Jacksonville Sheriff's Office said police were called to a home off of Newberry Road in Jacksonville in response to an unresponsive infant. Members of the Jacksonville Fire and Rescue Department also arrived and found a baby inside a hot car. She was taken to an area hospital where she was pronounced dead. An initial investigation indicated that the baby's father parked at a home, which also serves as a business, left the baby in the car for at least an hour before he remembered. He then pulled the child out, began CPR, and called 911. Temperatures that day could have reached 128 degrees inside the car after an hour. 29 children have died in hot vehicles in 2022 alone. It's an increase from last year's death, which included 23 child deaths in vehicles. Terrible. Okay. 17-year-old boy is wanted for murder of 2 North Carolina teens who were found shot to death Sunday afternoon on an ATV trail. Orange County Sheriff Charles Blackwood said a juvenile petition on 2 counts of first-degree murder was filed Tuesday for the unnamed teen. Lyric Woods, 14, and Devin Clark, 18, were reportedly missing over the weekend. Both of them were last seen last Friday night. 2 men on an ATV found the bodies around 3 p.m. on Sunday. Though the hard work of my investigators, along with the assistance of personnel from many other law enforcement agencies, and we have identified a suspect in this case, Blackwood said, we will now work with the local, state, and federal authorities to apprehend and present the suspect to the court system. The North Carolina legislature changed state law in 2019, halting automatic charging as adults for 16 and 17-year-olds. A judge, however, can transfer the case to the adult justice system with probable cause. The medical examiner has not positively identified the bodies or the cause of death, but family members identified the victims as Cedar Ridge High School freshman Woods and East Alamance High School senior Clark. The 2 were friends. Woods' stepfather reported her missing Saturday afternoon, saying he heard her taking a shower at around 11 p.m. the night before, and he believed she left through a back door that was unlocked. Clark, who lives with his father, was reported missing Sunday morning and was also last seen 11 p.m. on Friday. A tracking dog determined that Woods likely headed through the woods along ATV trails. A neighbor of the Woodses reportedly saw the girl in a vehicle around 3 a.m. Saturday, according to the missing persons report. Deputies believe she got a ride from someone in that vehicle, and it's not clear if deputies believe Clark, the suspect, or an entirely different person was driving the vehicle. We're not resting until he's in our custody in Orange County. Until then, our heads are down, and we are working towards that end. Wow. 2-year-old Texas boy has been found dead inside a stolen car after his father was shot and killed on Tuesday. Houston police announced Wednesday morning that a person of interest was in custody and being questioned. Executive Assistant Chief Larry Satterwhite said Tuesday night that a 911 call alerted police to a shooting shortly before 2 p.m. on Tuesday. When officers arrived, they found a 38-year-old man dead on the street. Satterwhite told police that investigators believe the victim met with another man at the scene and an argument ensued. The other man said the victim was shot. The other man shot the victim several times and drove off in his black SUV. About 5 hours later, a woman called 911 and reported her husband and toddler son were missing. Satterwhite said the information that she told police was that her husband was the earlier shooting victim. We never knew about the child until she called. Satterwhite said investigators intensified the search for the stolen vehicle. Finally locating it about 10 miles away from the shooting scene, officers smashed the vehicle's windows to get into the child. They rendered aid and they called for an ambulance. Sadly, it was too late. The child had passed in the car. At this time, we don't know why or how the cause of death. It could be something like heat exhaustion. We just don't know. That will be determined later through autopsy. Wow, that's so sad. The suspect remains unidentified and is described as a black man wearing a white t-shirt, black shorts, and a black Oakland Raiders cap. Investigators released surveillance video of the suspect Tuesday night, and they have not said if the person of interest in custody is the same man. Okay, now we have, this is about Gannon Stauch. It says that Colorado judge said last week that all force reasonably necessary can be used to make sure an El Paso County woman returns to court for her hearings in connection with the death of 11-year-old Gannon Stauch. Letitia Stauch was arrested in 2020. She's charged with a murder and related charges after prosecutors say that she stabbed, shot, and beat her stepson Gannon inside their Fountain home. Afterwards, she allegedly went to great lengths to cover up the crime scene. The boy's body was found in June 2020 in Pace, Florida. He had been stuffed inside a suitcase and left under a bridge. There is no date set for her murder trial. It has been paused in part due to numerous requests for mental health evaluations. Previous evaluations that took place at the Colorado Mental Health Institute in Pueblo have resulted in the same conclusion, that she is competent to stand trial. Defense lawyers challenge the findings and request new tests performed by out-of-state psychiatrists. During the exam, Letitia will have EEG monitor strapped to her ankle. Judge Gregory Werner said he would possibly allow another competency exam, but needs to consider whether an EEG monitor could impact a potential diagnosis. He also wants to consider what security and safety concerns are for people around Letitia Stauch during any subsequent evaluations. Meanwhile, Letitia arrived an hour late to her Thursday's hearing last week, resulting in the judge giving her a warning that she must appear at hearings. We had a conversation a while back about you needing to be here and what it would look like if you refuse, Werner said, adding that he told deputies to use all force reasonably necessary to ensure that Letitia Stauch leaves the jail on court days. One thing you do not have a choice about going forward is whether you're going to appear. Letitia told the judge that she didn't refuse to come to court, but she refused to go without hygiene. She reportedly insinuated that deputies were withholding toilet paper from her. And then she complained about the transport van lacking air conditioning. Letitia's next hearing has been scheduled for October 13th. Okay, now. Got some more stuff going on. Eliza Fletcher. So the mother of the Tennessee man accused of killing Memphis mother and wife and mother, Eliza Fletcher, reportedly claimed that the suspect is a good person and he's being railroaded for murder. She gave an interview to the Daily Mail. Her name is Virgie. She's 65 years old, and she doesn't believe her son, Cleo Abston, 38 years old, killed Eliza Fletcher, a beloved school teacher who was found deceased earlier this month near a vacant home in Memphis. The affidavit stated that Memphis police spotted vehicle tracks in tall grass, which led to a vacant residence. Officers combed the area, noticed footprints and an odor of decay before locating a deceased woman who was ultimately identified as Eliza Fletcher, 34 years old, next to steps near a driveway. A pair of purple Lululemon running shorts, which matched what Fletcher was last seen wearing, were found in a nearby trash can. The trash can was located 100 feet from the residence that Abston had been staying at with his brother. Abston was ultimately arrested and charged with Eliza Fletcher's murder. I talked to him, and he said he didn't do it. He said, "They're trying to put me in some stuff, Mom." I believe him. I don't believe he did it. If it comes out of his mouth, that's what I believe. He's just a good person, kind, lovable. Along with this murder, he has been charged in connection with the 2021 rape case. Abston has been charged with first-degree murder, especially aggravated kidnapping and tampering with evidence in the Eliza Fletcher case, along with aggravated rape, especially aggravated kidnapping, and a gun charge in the 2021 case. I don't know why they do what they do, his mother added, referring to police and how they allegedly railroaded her son in a 2000 kidnapping conviction that sent him to prison for 20 years. I don't deal with the police. I don't deal with the police, period. He left me when he was 16. They took 20 years of my son's life, and they need to fix that prison system. He remains in jail. Wow. Okay, now flown back to Florida. A Florida daycare worker is facing additional charges after police say security footage revealed several instances of child abuse at the Bradford preschool in Stark. 47-year-old Robin Bryant, identified as a daycare worker, owner's daughter, has been accused of using violent and threatening behavior towards the children at the daycare for years. In one instance, Bryant allegedly threw a bottle at a child who was sitting on his sleep mat and forcefully slams the child onto his back, which then caused him to hit his head on the ground. Around a week later, in another incident, Bryant allegedly places her foot on the mat and forcefully slides the mat into the wall, causing the girl to hit her head. Now, new charges have been filed after security footage reportedly revealed additional child abuse at the school. According to police, investigators began looking into the latest accusations in 2021 after an employee at the daycare shared a video with the child's mother, Taylor Williams, after an employee allegedly told the child, "I'll put my hands on you, around your neck, and I'll choke slam you." Okay. The report prompted other people to come forward, including mother Michaela Proctor, the parent of another child allegedly injured at the preschool. "It hurts me to my heart to know my child went through something like that," Proctor said. After he tried to pick his head up again, she put her hands around the back of his neck and she pushed his head down again. Then she done it again for 3 times total. The latest incident marked the 5th time police opened an investigation at the preschool, which has ultimately shut down in June after the Department of Family and Children's Services suspended its license. It's very upsetting that it continued for so long when they had this surveillance video. They had the police report. This was more than one person who came forward, Williams added. So far, there is no comment from police or the Department of Family and Children's Services on why it took so long to shut the preschool down. Meanwhile, Bryant reportedly made an agreement with the prosecution, which has delayed the case. You do have Robin Bryant in 2014 as well as 2015 on those cases. Both of those were referred to the state attorney for charges, said Barry Warden, assistant chief of police of the Stark PD. Bryant is facing 4 counts of child abuse, and now another employee is also facing charges. Wow, so it's a great place to bring your kids. Okay, that's going to be it for that stuff tonight, I think. Oh, we didn't look at, I just want to see Parker Taylor. Taylor Parker. Let's see. Okay, let's see this. So, in court yesterday, graphic 911 calls were played during the trial of the woman accused of murdering expectant mother, Reagan Hancock, and cutting out her baby. So, let's see, there were gruesome 911 audio was played for the jury Wednesday, September 21st, as the trial for a woman accused of murdering an expectant mother and cutting out her unborn child continued. Reagan Hancock's mother was screaming when she called 911 after finding her daughter dead. She stated in the call that her daughter had been murdered. The accused, Taylor Parker, also called 911 that day, saying that she had a baby and the baby wasn't breathing. And that was all after Parker reportedly faked a pregnancy for some time in an effort to keep her boyfriend from leaving her. In the 911 call, Parker told the dispatcher that she was on her way to the hospital to Idabel, Oklahoma, where her doctor practiced. She reportedly would not go to a Texarkana hospital. She stated she didn't want to go there because they hurt one of her last baby. Also was body and dash cam video that was played from the Texas Department of Public Safety trooper who pulled Parker over on the morning of the murder while she was on her way to Idabel. At the time the trooper pulled her over, he reportedly didn't know about Hancock's murder. Parker was pulled over for alleged reckless driving. The body cam video showed that when the trooper approached her, Parker said she was on the phone with 911 and was shaking. He reportedly saw the newborn baby with the umbilical cord still attached in Parker's lap. In the video, Parker could be seen telling the trooper that she just had a baby and needed to get her to the hospital in Idabel. Video played for the jury also showed a nurse who happened to drive by and pull over and offer to help. Parker continued to insist on going to the hospital in Idabel because that's where she said her husband was. Parker reportedly staged a fake business trip 3 to 4 hours away in Oklahoma to get her boyfriend out of town on the day of the murder. After the trooper got Parker out of the car and the baby was taken by ambulance to the hospital, the trooper reportedly found the placenta in the car. Hancock's husband also testified Wednesday, saying Parker had visited their home the night before his wife was killed, and she talked to her. He also said he got a text from his wife's phone on the day of her death. But he said it didn't sound like something she'd say. He was contacted by the neighbors that day who said that their dog was out. Well, sad. Okay, I think we're going to call it a night for night, guys. It's been like a crazy day and I've been up and around. I want to hit the massage chair before I go to bed. And hey, Mike, good to see you. Whispers back too tonight, so That's good. And Miss Craft. Thank you for coming in. Thank you for viewing us. Have fun. Hi, Jeanette. How's it going, Mike? So that's about. So we're going to have a big sale tomorrow, a really big sale. What was that? We're gonna have a big sale, really big sale. Where is that from? Is that crazy? That's not crazy. We're gonna have a big sale, really big sale. It's gonna be big, really big. It's gonna be huge. No, it is. It's gonna be huge. You're gonna love it. Hi, Pamela. So, like I said, if the weather is bad, it'll start earlier and run like marathon through until we do true crime at night. But if the weather is good where I can ride my bike and stuff, then it'll start a little later. All right? But we'll see. You never know. It could change too. I don't know. It could change that it could start. I could ride my bike and come back. I've done that before. Whatever. So we'll see. And other people can sell during that time depending on what's going on. But it's going to be a good time and a lot of fun going on. So I hope that you'll check it out. I'll put a thumbnail up later. I'm just exhausted. So I'm going to go and take a rest in the massage chair. But thanks for coming in and appreciate that. Okay, and what was I going to say? Good night, Pamela. Good night, Deborah. Good night, everybody in the chat. Prayers for all that need them, and we'll see you tomorrow, hopefully, okay? All right, everybody,
night,
take care.
everyone.
Good night, everybody. Bye. God bless. Love you guys.